Good evening and welcome back here to From Day One, Carf in Advent. Alright, so with that we will begin the rocking. With, of course, the mailbag of items from before, from the last time you and I worked together. Artifact chest key. Yay, we get a Kerf doll. Pretty Kerf doll. Okay. Alrighty, so we'll get back to more of our normal love. That's gonna be tonight, Sovereign Citizens in Court.
Hi, this is Attorney Mike Grab. I'm coming to you.
Mike, I'll be with you in just one moment. I promise I will. Alright, let's grab a few things. Oh, that's already done. Okay. And here we go for our first Sovereign Citizen from Hawaii.
Good morning. What's the cases for Mr. Dennis, please?
On the pages 7 to 37 of the chocolate calendar, William Dennis.
Good morning, Your Honor. Deputy Prosecuting Attorney Sarah McNamee for the state.
Good morning. My name is William Allen Richard Chikwesi Megasa for the dentist. I stand before you today under duress, and I object to entering your area of the courtroom. But I will do so out of respect for you as a person and not as my true authority, as I am a sovereign child of God. Before I enter your area of the courtroom, I respectfully ask you respect my sovereign teachings and beliefs as well. As a sovereign child of God and a member citizen of the legal and internationally recognized Polynesian Kingdom of Atui, I do not fall under your jurisdiction. That said, should I enter your area of the courtroom to continue this conversation regarding my motions to dismiss all charges or to remove my case to federal court? Yes, you may.
I love this judge already. Yeah, sure. Go ahead. And don't forget to hit like and subscribe.
Oh,
Get it.
what did I tell you about the doggies?
Good morning, Mr. Dennis. Good morning. We're here on your motions to dismiss filed on pages 9 through 10, 12 to 15, 17, 19, 21, 23, 25 to 26, 28, 30 to 31, 33 to 35, and 37 that's on the calendar. Is that your understanding, Mr. Dennis? Yes. Okay, all of them, right? Yes. Okay, is that your understanding?
That is my understanding.
Okay. Mr. Dennis, I have read through your motions, and I just have, on all the cases. I just wanted some clarification. Basically, it seems like the arguments on all your cases are the same. Jurisdiction. Yeah. It's the same, basically it's the same memo for all the cases. Correct. Okay.
Well, I am absolutely shocked here. There he stands with his staff of stupid, which I don't know how he got that past security, but there he is. He's got it. He's filed multiple motions which make no sense, but fine. But the judge asked him a straight question, and he gives a straight answer. It's kind of refreshing.
So what I'm going to do is we're going to have one argument for all the cases rather than have you stand up like 20 times and say the same thing. And then I'm going to give the state that opportunity to respond to that. So I'll give you a chance. I'll give you about 5 minutes to argue. I've read it, so I mean, you've seen me. I've worked on a case with you before, so I've read your arguments and I've read your papers and meetings. So I've read it, but I'll give you 5 minutes to kind of wrap up or to emphasize whatever you want to emphasize on that. Okay, then I'll give the state a chance to respond, and then you can have the final argument.
I really like the way the judge handles this. He's really a pro throughout this. You'll see that. That's really the way it should be handled. He isn't giving him a hard time. he filed too many motions. An attorney would get in trouble for that, but he's giving some leeway because he's pro se. But aside from that, he's doing the standard thing. You get about 5 minutes to argue. That's right. And multiple motions with the same argument. Let's just have them all at once.
Okay. Go ahead, Mr. Dennis. My motion is basically that I am a sovereign child of God. Okay, and I have God-given rights that are being denied at this time. I have rights regarding separation of church and state. I also have rights under the Constitution of the United States, which protects my inalienable and unalienable rights.
Wait a minute, if you're supposedly a representative of the kingdom of Atui, then you wouldn't be an American citizen, right?
To not have my forward progress impeded, to life, liberty, and the pursuit of happiness. I also have reference to documents that were sent to the Honolulu Police Department and law enforcement officers and treaties and things in effect that protect my rights. The question is, the Polynesian Kingdom doesn't exist. We have a country code. We have treaties. We're recognized by the international body. My rights denied by the United Nations, or the rights of indigenous people are being denied. So my human rights are being denied. All my rights are being denied by this court. That is why I'm requesting to go to federal court and have a jury of my peers. Okay. I'd like to give this to the prosecutor.
Thank you.
You're welcome.
Is that your memo, or?
It's the Honolulu Police Department Policy Law Enforcement Operation.
Okay, would you
It
like?
also includes letters by the United Nations, Jason Rosario, to all the police chiefs and deputy police chiefs, with asking them to cooperate with the Polynesian Kingdom of Tui during our transition into our nation.
Are you requesting the court to consider those letters too? Because I don't have them.
I just gave her a copy.
I know she got one, but I don't have one.
I was told that I could not submit any things with my motion. I had a whole packet, and I was told by the clerk at window 4 that I could not submit any exhibits, anything in defense of my motion. It was strictly a motion.
Well, if it's an item of law, I will consider that. Factual things are not considered generally at motions. So the clerk is correct in terms of factual exhibits or evidence. That's not considered a motion to dismiss. Items of law, like for example, you're educating me on the Supreme Court decisions and so on and so forth, which I've read. That if you want to give me copies of that, I can get it through the library. But if there's things like that, you can submit. But if it's just letters, it's usually not part of the record, because motions to dismiss are based solely on the record and what's filed and on the law. Right.
That does make a lot of sense. I run into this a lot in civil practice, and it's pretty much the same thing. In a motion to dismiss, you're just looking at the pleadings. You're saying there's a defect, the plaintiff hasn't stated a proper case, and this is in a criminal context, but it's the same thing. A motion to dismiss, you're just saying that the charging document is wrong or something like that. If you want to get into the facts, or I didn't do it, or it didn't happen the way they said I did it, well, that's a factual thing. You need to take some evidence. In a civil context, you can do a motion for summary judgment and use things like depositions and discovery to bolster your position. But a motion to dismiss, you're just looking at the law and the pleadings.
So if it's letters, I don't believe that would be relevant to the decision.
This is the drips from the United Nations on the rights of indigenous people, which all my rights are being denied. And your own Constitution as well, because you do defend the Constitution.
Yes, right? I do.
Okay. And you do defend Hawaiian law as well?
I defend the Constitution.
That's Hawaiian law?
Let's just say I'm going to defend the United States and the state Constitution. Okay, we can proceed from there.
Here's another good example of the judge getting it. What's going on here is Mr. Dennis is trying to goad him into a fight about Hawaiian sovereignty. And the judge sees it, and he's not afraid of it because the argument has no merit. But he wants to sidestep it and make this proceeding go forward. So, yes, when you take an oath to uphold the Constitution of the United States and the Constitution of the state where you're licensed.
Do my rights stand and say that this judge
Miss, I forgot.
McNamee, Your Honor.
Okay, I'm seeing your name on the record. So, Miss McNamee, you may proceed.
Thank you. The state would like to make oral arguments that this motion is without merit, given our precedent that we must follow. In State v. Fergustrom, the Intermediate Court of Appeals stated that the state of Hawaii has lawful jurisdiction over all persons operating motor vehicles on public roads or highways within the state of Hawaii. And all of the offenses at issue here today are in regards to operating motor vehicles on the public roads of Hawaii. The state does respect the Native people's right to inherent sovereignty and self-governance. However,
that's interesting. I don't know exactly what the prosecutor means by this. It probably isn't that big of a deal, but that's not something I would say if I was a prosecutor.
I'll save you, Mike. Actually, Hawaii with Polynesian and everything else, it is something usually they have to say. It's kind of like someone here, say 30, 40 years ago, saying that I am perfectly fine with the sovereignty of, well, I better not say it because I don't want it to come back and bite me in the ass. But yeah, that kind of reference.
In this circumstance, I would just say we have authority over this particular matter.
If Mr. Dennis is driving on the roads of Hawaii, then he is still subject to the jurisdiction of the court. And HRS section 701-115-2 states that, excuse me, that was the wrong section. It's not in this memo. The jurisdiction of this court applies to anything that happens within this state. And the right to drive is not an inherent right, it's a privilege, and to use the roads. And the state would just like to argue that these motions, are without merit. As recently as a few weeks ago, on July 30th, 2015, the Intermediate Court of Appeals issued a summary disposition stating that very thing. So Fergustrom is being upheld, and this court does have jurisdiction.
Thank you, Ms. McNamee. Mr. Dennis, you got the last.
You and I know that driving is a right.
No, we don't.
To all citizens. You cannot impede my forward progress in any manner.
Yes, we can.
You're also asking me to commit a crime, and I take umbrage for that. When I came to Hawaii to get legal credentials, I had to first look at is Hawaii a state of the United States? In my opinion, it is not. I am an American citizen. And I know the Constitution that Hawaii was illegally annexed into this country as part of the United States. You're asking me to take credentials for a state that I do not believe exists.
Well, this is awful, but somewhat refreshing. I did another video on Mr. Dennis, and he was speaking in mostly punctuation for some reason, and punctuation and mysticism. It was a mix. And you couldn't tell anything. Now, here he's simply making a bad argument, but he's stating it plainly. He doesn't think the state of Hawaii exists. Well, it's nonsense. It's just convenient for him to not have to get a driver's license, but that's the position he's taken. It's silly. It's not going anywhere, but at least he just said it.
Doing so is committing a crime against my God, against myself, against the Hawaiian people.
This is rampant, even beyond sovereign citizens, this virtue signaling. He doesn't care about the Hawaiian people or anything else. He wants to have attention and not have to get a driver's license. This pretending to be holier than thou and care more and understand the history deeper or something, it's complete nonsense.
I will not change who I am as an individual. And asking me to change who I am, this is serious egregious against me.
Is egregiancy a word?
But I do not respect that. So I refuse to commit a crime by taking credentials with Hawaii until I have irrefutable proof that Hawaii is a state of the United States. It was also noted, if you notice, I have not actually committed any violations. I have not been stopped for anything except for the color of my plates. I could have my own name on there for that matter.
Yeah, you really could, and you'll get pulled over for not having valid plates.
I don't have to be part of anything. I have a sovereign right as a child of God, protected by the United States Constitution, protected by the Declaration of Independence, protected by your own Pledge of Allegiance, because the United States is a republic. And a republic respects the inalienable and unalienable rights of the individual and the God-given rights of the individual. So any other ruling short of that indicates the United States is not a republic. And therefore I question again, who is the United States? Who is Hawaii?
Oh, this is Rich. He's been citing the Constitution, which he seems to like quite a bit, and I agree with him on that. I like the Constitution too. But now he says, who is the United States? After claiming to be a citizen of the United States, asking for his case to be, I guess, transferred to federal court, which the judge can't do.
I have no proof. You have given me no proof. I have given you everything. I've given you my life, my history of who I am, and how I support people. I unite people. I don't separate people. Every act against me is like an act of war. You're trying to make me something I am not. And I will not change no matter how you rule today. Because I stand in my truth as a sovereign child of God. So if you want to disrespect God, go for it. Because if you judge me, you will be judged as well. But I stand by who I am and my decisions that I make as a sovereign individual. That's all I have to say.
Again, I actually really like this argument compared to his other appearance in Sovereign Citizen Court number 8. He just simply makes a bad argument. He denies the existence of Hawaii and implies that he's not sure about the existence of the United States. He says he has a right to travel and he can't be impeded. These are not good arguments, but they're clearly stated, so one can just make a ruling on them.
Thank you, Mr. Dennis. Well, I'm not judging never do that, but we are here on a motion to dismiss. I'm not here to determine whether you have committed a crime or not. That's not an issue with the court. The issue is whether or not there is significant, there is a basis to dismiss the cases against you based upon your claims that the court has no jurisdiction, based upon your claim that the charges violate your constitutional rights for freedom of travel, as you have cited, and also, I guess, you argue about being a sovereign child of God. Based upon the arguments of counsel and a review of the motion that was filed and the arguments made, the court finds that the court does have jurisdiction in this matter. The court does understanding that the state in cases of State versus Ferguson and in State versus Jim have specifically held that this court has jurisdiction on traffic matters regards to the sovereignty issues or allegations made by defendants. The court does recognize those cases and recognizes the decisions based upon that. Based upon also, the court addresses on your claim that the citations violate your right to your constitutional right to travel. The court finds that the constitutional right to travel Act under the cases that you have cited, specifically the last case that you have mentioned in your memo, Zolo versus Williams, specifically states that the right to travel is the right to travel between states, or in some of the cases that you talked about, it was travel between the United States and another country. It does not talk about the right to drive without any regulation in any vehicle. So I don't find that those arguments are convincing in terms of what the United States Supreme Court has said. In regards to your request for removal to the federal district court, I do not find that there is a sufficient basis for removal of those matters to the federal district court. Mr. Dennis, if you want to follow through on that, you should be filing an action in the federal district court yourself and ask for the court to stay these proceedings. But the court on its own cannot send over something to the federal district court saying you take it. Unless there's a clear federal jurisdiction issue, that this court cannot just package up these cases and send it to the federal district court. Based upon that, the court will deny all your motions to dismiss. State to prepare the order, please.
Again, I really like this judge. He gives a really nice, dispassionate, reasoned response to this. Of course, he's going to deny these motions, and of course, he can't remove the case to federal court. He's got no basis to do so, and the federal court would throw it back if he tried. It'd be really hard here to just now say, motion denied, take your staff as stupid, and go home.
Yes,
Thank you, Mr. Dennis. Have any other case number? Oh, yeah. Yes. Have a good day, Mr. Dennis. Wish you as well.
Alright, so that takes care of that one. Let's move on. Alrighty. So our next sovereign moron in court is on the docket. Mike, take it away.
One for you today. We've got 2 clips and our first appearance of the Fez on Law Talk with Mike.
We got more.
Of having a suspended driver's license on April 12th. What is your plea, sir?
Well, just have a couple of questions before we proceed. I don't understand the nature and cause of the charges.
He's confused about his charge of driving on a suspended license. And don't forget to hit like and subscribe.
No!
Or the
The doggies are nice.
You're
Stop
charged
trying
with
to...
driving on a suspended, canceled, or revoked driver's license.
Okay, is there a sworn statement against me or injured party?
I believe you probably received a citation on April 12th. That would be the criminal complaint filed against you.
Yep, that'll do it. Anything else for you?
Okay, and is there a injured party or damage to property here?
It's charge brought by the city of Las Vegas, sir.
Okay, so the city's the victim in the case?
The city is the charging.
So they're the victim.
What is your plea on
If the city is the,
Mr.
if they are
Martinez,
the
today is your
victim,
Mr.
I would like
Martinez,
to
I am in
move
charge
this
of
to
this
a federal
courtroom and
court.
you're going to stop
No,
it.
we are in charge of the courtroom.
No.
I don't know. Kind of looks like she's in charge to me.
Marshal, would you show Mr. Martinez the inside of our holding tank, please? You're not going to tell me who's in charge of my courtroom, Mr. Martinez. Go ahead and go with the marshal. That
Goodbye.
is direct contempt of court.
You are in contempt.
Okay, Mr. Martinez, since you have informed me that I am in contempt of court and that you are in fact in charge of this courtroom, I'm going to go ahead and sentence you today to direct contempt of court. I will give you an opportunity to apologize if you choose to do so and behave in a manner that I consider appropriate for a courtroom. Would you like to do that today, Mr. Martinez?
What would I be
It is a
apologizing?
yes or a no question.
What would I be apologizing
For your direct contempt of court, sir.
Wrong answer. The correct response was yes. I'm sorry, Your Honor.
All I was asking was legal questions, man.
I disagree, sir. I'm going to ask you the question one more time. Did you wish to apologize and proceed in a manner I consider appropriate in this courtroom or not? Okay. Direct contempt, I'm going to sentence him to 15 days in jail. Okay, thank you.
The Sixth Amendment grants me that.
No, it doesn't.
Sir, I
Shut
would
up,
suggest
sir.
you stop speaking now.
Well, that was a fun little warm-up. Just a standard sovereign citizen fail in the most common way possible. This next clip is just deliciously awful, and we're very excited. It's the first appearance of the Fez on Law Talk with Mike, so I invite you to come along on a little journey with me, wherein a man in a Fez attempts to say something intelligent over the course of about 5 minutes and fails miserably.
Okay, this is the matters of State of New Jersey versus Emir Colonel Chauncey L., also known as Cornell Hall, also known as Cornell Dixon. No. We're not going down that road. We're not going down that road.
Go so crazy, someplace else.
Everybody else sit down. Have a seat. Have a seat. That's 0807727I, 0302282I, 0804441I. Mr. Luciano, denote your appearance for the record. All right, last time we were in court, The court made a ruling. Mr. Houston, you know your appearance, please. All right. Court made a ruling, in essence, allowing Mr. L to represent himself in these matters. Subsequent to that, the court has received 2 other filings from Mr. L.
And wow, were they awful.
So you are. Are you a licensed practitioner? I am not. Well, on the other side, sir, on the other side of the rail. Thank you. Subsequent to that ruling, the court has received, I believe, 2 other filings from Mr. L. And in one of those filings, he's raising a jurisdictional issue. So the court, upon further reflection, given the nature and complexity of the issues that have been raised by Mr. L.
I have to think that was a cute little euphemism by the judge for just saying, given the complete craziness of these filings.
The court is rescinding its previous ruling and will make a determination that until a licensed practitioner in the state of New Jersey substitutes in for Mr. L, the court will enter an order that Mr. Kiesler will remain as counsel.
Objection. For the record.
It's overruled.
Wait, is he wearing a fez?
It's overruled, and he's right.
Objection. For the record.
He's wearing a fucking fez.
The Office of Public Defense or John J. Kiesler to take this matter. They represent this.
Very well.
The office, for the record.
I got it. Until there is a licensed practitioner in the state of New Jersey.
Objection. The practice of law cannot be licensed by any state.
Yes, it can, and it is by every state.
And that's according to Schwab versus Board of the Examiners 353, U.S. 238, 239.
Objections overruled. Until there is an attorney, a licensed practitioner here to represent Mr. L, court is recognizing Mr. Kiesler as the attorney of record.
That is actually really interesting to me. Apparently he allowed this guy to represent himself. The last hearing, he's rescinding that order and saying, no, we're going to have the public defender represent you until you get somebody else. I didn't even know they could do that. I'm not looking it up. I'm sure he did. I'm sure he looked at the crazy pleadings put before him and thought, I'm not dealing with this guy. I've got to get somebody who knows something about the law that I can actually talk to. And I'm sure he did his homework and knows that it's within his discretion to do so. So he said, no, you get the public defender whether you like it or not.
Objection. For the record, on the record, and let the record show, the rule of professional conduct states, RPC 1.0, refer, a law firm denotes a lawyer, a lawyer is
Wait a minute, did he say of the record, for the record, and let the record show?
a law partnership, professional corporation, sole proprietorship, or other association authorized to practice law, or lawyers employed in a legal services organization or the legal department of a corporation or other organization. http www.judiciarystate.aj.us.
Maybe this is just for the attorneys, but citing a case which, by the way, doesn't say anything. He's just giving a definition of attorney, which doesn't help or hurt his cause. It's just kind of irrelevant to the proceedings. But he then does cite the case via the website, not the actual, not to a reporter the way, somebody would actually cite a case in the normal course of, practicing law.
Rules.
Until an attorney authorized to practice law is representing you, Mr. L, the public defender's office, Mr. Kiesler, will represent you.
Objection. For the record, the corporate body politic that has authorized the Aboriginal Law Firm's Secretary of State authorization number
Well, there's just so much to unpack here. First of all, he has the fez, which is just fantastic. I really like all of these videos better if we've got some costume. The obviously the wizard robe from Hawaii or the Davy Crockett get up out in Montana. It always makes it a little bit better. The other thing that just cracks me up is he's got his right hand up the whole time, which is just silly and it doesn't really help anything. It's also impractical. You need your hand, but he remains with that. And then finally, he's making reference to Aboriginal law. I just looked it up so I can try to figure out what that is. If somebody has some grand idea of what Aboriginal law is, please put it in the comment section below. Everything I saw was referenced to Canada. We're in the United States here, so I think I get what they're trying to get at, but it's just sort of a fairy tale. I don't think that any such thing really exists in any meaningful way.
003. The fact that you listen to me, listen. That's it. That's it. I'm tired of this now. You coming in here again with this mess, and I'm going to call it mess on the record. You're going to be arrested. We're done. This matter will be continued till November 10th. If there's a substitution of attorney from somebody licensed, the fact that the Aboriginal law firm may have some saying with the Secretary of State is not the issue in this case. It's a question of whether, in fact, the law firm has an attorney licensed to practice in the state of New Jersey. The matter is continued to November 10th, 2008 at 9 o'clock. Thank you. Objection. I'm done.
I really like this judge. She's having none of it. One slight style difference, although I kind of like it because I kind of like the way the video ends, but that doesn't really matter. And it's implied in there. But I think if you really want to close it off, you say, you know, this case is adjourned. So that we stop with the talking. But this guy just continues to just say objection to everything and then spew complete and utter nonsense going nowhere.
You can put whatever you want on the record. I'm done. On the record, and let the record show.
He did say that. Jesus Christ.
A written approval now June this, a demand for termination or state the proper jurisdiction to all matters concerning the items of subject. I know, I got it. I already placed it on the record. Place it on the record. November 10th, 9 o'clock. That's it. For the record, I give honors to Judge Smith. Thank you.
Oh, you gotta love idiots. You got another one for me, Mike? I'm hoping you do, because I know you're usually good for them. Oh, we're gonna go to Michigan? Okay, let's have some fun.
This is just...
Is this the... Oh, this is this guy. Oh, awesome.
Mr. Morrow Bay. This is Judge Middleton. Can you hear me?
Oh, yes, I can.
All right. We're waiting just a bit for the prosecutor to log in.
Understood.
Mr. Perdue, we are live, even though we're not doing anything here. We're live on YouTube and live on the Zoom platform. As soon as Casey Johnson, the prosecutor, comes in, we'll conduct our business.
Okay, so like I said, we've got our old friend Judge Middleton. He first appeared in Sovereign Citizens in court number 11, and he's had a few appearances since then, so he has his own playlist. I call it Judge Middleton's Greatest Hits. Links to both of those in the description below. And we also have Samir Siraj Mar-O-Bay, who also appeared in Sovereign Citizens in court number 11.
That's not my name.
Well, I know you're known to the Secretary of State by your birth name, but you prefer to be known as Samir Siraj Mar-O-Bay. And
I'm a national of Atlanta.
I listened to this 3 times, and it sounds like he's saying he's a national Atlanta. I know that's not what he means, but you know, I'm not interested in indulging him in his fake name or his fake nationality.
I understand.
My nationality. But I thought, did you take an oath to this?
Did
To
I?
uphold the Constitution? Yeah, to uphold the Constitution
Oh, yes.
and the treaties.
I don't know about treaties. Those are federal. This is state law.
I know. I shouldn't even be here. I should be somewhere federal. I should be in a federal courtroom, and you still haven't provided any delegation of authority order.
Well, wait a minute till the prosecutor gets here and you can go through.
This is why I like Middleton. He's just so calm about it. You can exchange pleasantries and say, hey, we're waiting for the prosecutor, but now he's jumping into his crazy arguments. And Middleton's only response is the rational one, which is, yes, this is crazy, but it's also ex parte and crazy at this moment.
Hi, this is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please hit like and subscribe, or I'll be personally offended.
Now that kind of dog plug I might like.
I know, and I'm still waiting for my delegation of authority order. I'm still waiting. I never got it in the mail. That's Article 3, Section 2. You took an oath to this. You know it. I shouldn't be here.
You could fix that. You could stop driving a damn car.
Yeah, I like that, Judge.
I absolutely love it.
And then you wouldn't keep coming here, and you wouldn't have to deal with me. I don't have to deal with you. Which is
But a driver. But isn't driving a commercial terminology?
No.
No. In your universe, maybe it is, but in this one, it's covered by Michigan Motor Vehicle Code.
Yep, it sure is.
So what about Black's Law Dictionary? Does that not count?
As far as I know, that doesn't control Michigan traffic legislation.
And as far as I know,
but what would an experienced Michigan judge know about Michigan law?
You can't make up rules to undermine the Constitution, and no matter what rules or codes you make up, it doesn't supersede the law.
Here comes Mr. Johnson. I don't disagree with that. One of us keeps making up rules, but I don't think it's me.
Oh, yes, the understatement of the day.
Mr. Johnson?
I'm pretty sure it is.
All right, well, let me call the case. This is file 21213ST. The actual title on the ticket is People versus Samuel Rufus Perdue. The defendant is here. He prefers to be known as Samir Siraj Maro Bey. I don't think he ever lawfully changed his name, but he goes by that name, and he has every time he's been here. He's charged once again with driving suspended second offense. It's alleged that on or about January 31st, he was operating a vehicle here in St. Joseph County while his license was suspended. He also got a ticket for speeding, so he tends to go too fast, always doesn't have insurance, and he doesn't have a license. He has two previous cases already pending. File 202073 is a driving suspended charge from September 17th. You like that one so much, he got another one on November 25th. One or both of those cases he was speeding. That's file 2026653. Mr. Marley has a different view of the law. He wants to represent himself, which I've allowed, and we had agreed to set those two earlier cases for jury trial. As we just
Wait a minute, Mr. Middleton. I'll get right back to you. I just happened to notice. Is Mr. Purdue or Morrow Bay, is he actually sitting on the stream call court in the front seat of his car? Please, for the love of fuck, or whatever tickle monster you believe in, not tell me that he's here because he's driving illegally, sitting in court in the front seat, driver's seat of the car. Please tell me that's not the case.
discussed earlier, sir, they can't do it. Excuse me?
I said, I'm sorry, I can't represent myself. I am who I am.
I really do like Judge Middleton, but I would have taken this opportunity and say, you know what? I agree. I'm going to appoint the public defender for you.
All right, but you don't wish to have a lawyer, is that correct?
Oh, no, I don't need one.
All right. Well, now you have your third driving suspended charge, and I told you the last time, if you did another one of these, I was going to set a bond, but I'm not going to. Let me tell you this right now.
I'm a traveler, not a driver, for the record.
We're all trapped in this universe. At any rate, you haven't been convicted of anything. You've been accused 3 times, but you do not have lawful authority to drive in Michigan. If you drive again in St. Joe County, I'm going to set a bond, and you'll either post it or sit in jail while we await the ability to try your case. I can only leave you in jail for 28 days. But am I understanding once again, sir, you wish to have a jury trial in this matter?
For my national peers, because I'm a national of the land, and you still haven't proven jurisdiction. I challenged jurisdiction a long time ago, and it's never been proven, and I'm still waiting.
All right. I had that discussion with a guy that was in jail once. I said, well, you're in jail. I guess you're in my jurisdiction. Let me tell you this. My jurisdiction is St. Joe County, and stop driving in it.
I don't drive. I'm a traveler by law. And I've already sent you paperwork, and you never responded.
Yep, Mr. Perdue, you make the same horrible arguments every time, and they don't get any better.
Well, because I'm not required to respond to it. You've got a skewed view of things. If this was this easy, everybody would declare themselves their own country and everybody could do whatever they wanted to. So rules only apply to you.
No.
The rest of us suckers are stuck complying with the law. So let's just figure out who the witnesses are, and we'll also set this to a jury. Casey, who have you got for witnesses?
Just a second, Judge. I'm sorry. I had his other files open.
Be here special appearance only because I have to. Because if I don't be here, you're going to see your criminals to come get me if I'm not here. So I'm only here under threat, duress, and coercion.
Well,
just to put that out there.
You're sitting in the driver's seat of your car.
Oh my God, he is.
Your headgear because I think it's part of your beliefs. So I'm not going to push it. But you're sitting in the damn driver's seat. What's the witnesses?
You're sitting in the damn driver's seat at the hearing for multiple offenses of driving without a license.
Jesse Raymond, Your Honor. That's it.
Oh, the so-called police officer who pulled me over is a witness also?
And a certified driving record.
Isn't that a conflict of interest right there?
No.
No.
He work for the court.
He doesn't work for the court. The court's in the judicial branch. He's in the executive branch. Plus, you keep driving too fast. So you're a traveler. You get to travel whatever speed you feel like. You don't have to have insurance, and you can do what you want. All right. Well, anyway, I'm just gonna set this on the jury list with the other 2 cases. Now, let me say this again. If you drive again and you get another citation, I'm gonna set a $1,000 cash bond, and you can sit in jail. So my strong advice is to stay out of St. Joseph County.
So you do realize
you're already driving there. So I'm gonna mute your microphone.
Thank God.
I'll
I love it. I love him muting his mic like he should, and I'd really like to know when this jury trial is. I got half a mind to go over there. It's not that far from Chicago, and just watch this whole thing go down.
For a jury trial on a date to be determined. All right, that completes that.
No, convert a liberty into a privilege, license it, and attach a fee to it, right? You do know that, right?
I don't make the law. I just try to apply it. All right, we'll set this for a jury trial the next date.
Your statutes and your codes are not the law.
That's an argument that has no end. If we live to be 112, we could continue to have this argument. he wants a jury trial, he's entitled to have one, and we'll get there when we can get there. All right. Mr. Kaufman, I'll be with you in just a moment.
Don't worry, Mr. Purdue pops back up, I believe. There he is.
Mr. Purdue, you're good to go. We'll set this for jury trial with your...
My name is Samir Bey. I thought I already told you that.
Sometime, yeah, you told me that. All right, thank you. I'll be in
You don't
touch.
respect the law. You're a criminal.
Well, one of us is.
One of us is. AKA him. Alright, do you have one more for me? We're gonna go to Florida for this one, Mike? Okay. Well, let's rock and roll in the good sunshine state of Florida. You got it?
All right, we did Mr. Davis. Let's go to Mr. Young on page 18, 19, and 20.
Judge, he should be approaching. I spoke to him earlier this morning. He does not want the public defenders to represent him. He's going to be representing himself pro se.
We all know this train wreck isn't going to work, but let's watch it unfold.
And don't forget to hit like and subscribe.
No, I told you the dogs are happy.
We went through this before with Mr. Young, I believe. Mr. Romero, he was up previously and he couldn't get through the Ferretta inquiry that I tried to go through. He's going to have to file a motion in order to have his division judge deem him fit to represent himself, Mr. Romero. So this morning I'm asking you to step in and represent him. I remember the what we went through last time we were up on the other allegations, Mr. Romero. So I'm asking you to step in.
Section.
All right, I'm keeping him muted, guys. Keep him muted because he's disruptive and he disrupted the court before and he had numerous outbursts. So, Mr. Romero, please represent him for the purpose of today's hearings on page 18 through 19, 20.
Judge, I will follow the court's order. If I could have 1 moment to attempt to speak to him again then.
All right, not a problem. Thank you.
Well, so far this hearing is going just fine with the defendant's microphone muted and the public defender speaking on his behalf. But wait, there's more.
All right, Ms. Lindsay, just let me know if you're back and we can get started. Thank you.
Yes, Judge, I'm back. Thank you.
All right, perfect. Thank you. All right, Mr. Romero, did you have an opportunity to speak to Mr. Young?
I did, Judge, and Judge, I just, in speaking to Mr. Young, he once again wanted me to reiterate the point that he does not want me to represent him. He wants to represent himself, and I did tell him I would go ahead and that would be the first thing I would address on the record.
All right, I understand. All right, Mr. Young, let me address them. All right, Mr. Young, good morning.
Good morning.
All right, Mr. Young, it's my understanding that you wish to represent yourself, correct?
What's your name? I don't know your name. Oh, Mrs. Blackman. I would like for you to address me as Noel, if you don't mind.
No. Her name is not Mrs. Blackman. Her name is Your Honor, Your Judge, something like that.
And we're off with the horrible, horrible start. I want you to address me as something other than my name, and I'm not going to address you properly.
It's Judge Blackman, sir.
Judge Tabitha Blackman, I'd like for you to address me as Noel, and I also like to be grandfathered into the grandfather clause of 1867 that Nina just mentioned with the Peonage Act, and then also I'm accepting, since I'm representing myself, I'm accepting all charges.
Wow, what a pile of gibberish. This is going nowhere fast. But wait, it gets even better.
I'm also reserving all my rights and remedies without subject matter jurisdiction leaving me. All right? So with that being said, I also would like to appoint you, Judge Tabitha Blackman, as my fiduciary trustee.
This is quickly becoming my favorite crazy subset routine. He does a nice job here, but it's not as good as this guy.
I'm sorry?
I declined a request for me to be a trustee. Noel Young, they are charged
I'm not the trustee for the case.
burglary, unoccupied structure, unarmed. I wish you the best of everything. Eric Solomon, Eric Solomon, Eric Solomon.
To close, settle, and release all proceeds to me immediately under, and I would like to incite Title 50, Stat 4035, B2 for full acquittance and discharge without recourse. And today's date, I think, is April the 9th, 2021.
I mean, just wow. I think he's got 27 charges against him, and he wants to appoint the judge as his trustee, and I guess discharge all the charges and maybe get some money too. I don't know. It's really out there.
All right, sir, I haven't made a determination yet whether you can represent yourself. As I tried to do last time you were off, I needed to go through what's called a Ferretta inquiry. You remember when I tried to go through the questions? I need you to answer these questions as I ask them in order for me to make a determination as to whether you can represent yourself, okay?
I'm really impressed with this Judge Tabitha Blackman. She's doing a very good job here. She's really maintained her calm through all this. She knows exactly what's going on here. She knows that this guy's not capable of representing himself, but she's going to go through on the record and do it the proper way. And she really has good judicial demeanor.
I never understood what you was talking about the last time because you weren't a part of the case. And I always want to tell you that if you are are you licensed to practice nursing, because to give those kind of telling me instructions to go get screened for medical. Do you have a medical license?
Sir, please answer the questions as I ask them to you. If you fail to respond appropriately, I will appoint the public defender's office to represent you and not allow you to represent yourself, okay? Okay, the first question is, have you ever studied law?
Yes.
These are yes or no questions, okay? Have you ever represented yourself in a criminal action?
No.
Do you understand the charges against you? There are 27 listed today. Do you understand each and every charge against you, sir?
I don't understand each and every one of them. No.
I really like this. This is beautiful. The sovereign citizens love to say they don't understand, and it's like they think it's a cute wordplay. But in this circumstance, it has a very specific legal meaning. She's asking him questions, and if you answer them the wrong way, then you can't represent yourself. And saying you don't understand the charges against you is definitely answering it the wrong way if you want to represent yourself.
Okay. Are you aware of the maximum penalty for each charge?
No, I'm not aware of the maximum penalties for each charge.
Okay. Are you familiar with the exact legal elements for each charge?
No, I do not understand the elements of the charges now.
Okay. Do you realize that if you are found guilty of more than one of these crimes, this may result in an order that orders you to be sentenced consecutively? That means one after another.
Well, I can say to you...
It's a yes or no question, sir.
No, Your Honor, because I'm not the entity and I wish not to participate in religious ceremony or even to do...
All right, so based on his answers, I do not believe that he meets the threshold. I haven't even gone through all of the questions to represent himself. He doesn't understand the severity of the charges. He doesn't understand what the charges are, the severity of the maximum penalties. He's not familiar with the legal elements. At this time, the court does not find that he meets the requirements under Ferretta v. California, 422 U.S. 806.
She did a really nice job there. She just made a great record. He obviously cannot represent himself. His answers made that very much so clear. I'm not familiar with this particular set of questions because I don't do this, but it looks like it's a standard set of questions to determine whether or not you can represent yourself, and he clearly can't.
From 1975 to represent himself. Mr. Romero, so that means that I am provisionally appointing your office to represent him, sir. I maintain the finding that have been signed by the original judge that signed the warrant on counts 1 through 27. Are you waiving reading of counts 1 through 27, or do you want me to go through them one at a time because I can?
I'll waive.
All right, so with regards 1 through 27, there's already been an order put into place by the judge that signed the warrant with regards to requirements for each of the counts. Mr. Garcia, is the state just requesting that I leave those requirements in place, sir?
Yes, Your Honor.
And Mr. Romero, do you have any legal objection to me leaving the requirements set by Judge Rabolo in place?
Well, Judge, legal requirements is obviously he's having his magistrate hearing. Those are just bonds that were set in place by the judge who signed the warrant. Obviously, you could revisit those. So at this time, pursuant to my conversations with Mr. Young, there's no way, from what he advised me, that anyone's going to be able to post his monetary bond. My understanding is, as the court pointed out, I believe he was here before the court recently. He was arrested. He was given a release conditions. From what he advised me, at this time he is residing with his father. And from what he advised me, he wants to participate in his defense. From what he advised me, if he's going to be incarcerated with these types of bonds, he's not going to be able to participate in his defense because he's going to be locked up. So, Judge, he is asking me for the court to consider reducing the bond for a total bond of $20,000. And also, my understanding in speaking with this gentleman, I believe he has several medical issues. So I am going to be asking for a medical screening order on his behalf, Judge.
Okay, I will sign that medical screening order. I find that Judge Rabolo's total bond amount of $240,000 to be more than reasonable.
I really like this video for just this reason. It shows the difference between somebody representing themselves, especially somebody who's got, crazy sovereign citizen ideas in their brain, versus an actual professional. This is a public defender, and he handled that with grace and style. Waives the reading. We don't need to read 27 charges. They have them in writing. They know what they are. It's not helping his client to spend a half hour reading the charges out in court. And then he makes a reasonable request to try to reduce the bond. It sort of doesn't get anywhere, but he doesn't have a good argument, but he makes the best argument available. It's clear to me that he's a good, competent defense attorney. And he also does get the judge to order a medical evaluation for him, which is required. None of these things would have been done, as you could tell, from the little bit when he was representing himself.
When the allegations are that he stole more than $1,232,360, and all of Judge Rabolo's other orders shall remain, including but not limited to the Nevia requirement, full collateralization. All properties used for collateral should not be further encumbered or liquidated during the pending of the proceedings. The state can object to any Nevia provided. Paragraph 6 remains. Paragraph 7 remains with regards to the surety that shall be provided within 10 days. Is to be monitored by pretrial release level 1, lockdown, no alcohol, no drugs, random testing, no driving. He shall not possess any firearms. He shall surrender his passport and may not reapply. He shall also have no contact with any of the alleged victims, direct or indirect. Is there anything else from Mr. Romero or Mr. Garcia on his case?
No.
All right, good luck to you, sir. Be in touch with your attorney. You'll have to file a motion to represent yourself with your division judge so that the division judge can also go through the Ferretta inquiry. Good luck to you, sir. Next is Mr. Wilson on page 21.
Thank you very much. And Mike, I will leave you there, and we will leave part 2 at that point as well. Make sure you do like, share, and subscribe. Get us to where Boxing Extras and YouTube will pay attention of 5,000 views and 1,000 subscribers. Till we meet for the Bigfoot Sounds part 3 of Midnight in the Desert. Make sure you do like, share, and subscribe, and it's always a great new world to release the Krakens.